All right, so we're diving into trusts today. And, you're prepping for this law exam. We're going to be looking at the three certainties,
Yeah,
which are really, really key when you're trying to make sure a trust is legally sound.
absolutely. Yeah.
It's kind of like, when you build a house,
Mhm.
you need that strong foundation. And in the world of trusts, these certainties are it.
That's a great analogy. In the simplest terms, a trust is basically when you have someone, the trustee, managing property for someone else's benefit, the beneficiary. And for a trust to actually,
Yeah.
be valid in court, you need these three elements in place: certainty of intention,
Okay.
certainty of subject matter,
Got it.
and certainty of object.
Okay, so let's break these down one by one.
Hmm.
Certainty of intention. I mean, that sounds pretty straightforward.
Mm-hmm.
You need to be sure that the person who's setting up the trust actually intended to create a trust, not just like
Yeah.
a casual wish or something
Yeah.
like that, right?
Yeah. Yeah. It seems really simple, but,
Uh,
historically, courts really struggled with this a
Yeah.
lot. There was a time when even vague, hopeful language
Hmm.
could lead to a court like imposing a trust, even
Right.
if that wasn't what the settler really wanted.
So how did things change? How did the legal thinking shift to prevent that from happening?
Yeah.
Because that's, I mean,
Mm-hmm.
you wouldn't want some kind of casual comment to just turn into a legally binding obligation.
Exactly. And that's where these cases,
Right.
like Lambe v. Eames, became really important.
Okay.
This case was a turning point.
Okay.
The court decided that simply using words like hoping or desiring wasn't enough to create a trust.
Right.
They said you need clear, unambiguous language
Okay.
to show a real intention to create this legally binding obligation.
So what are some examples of wording that do indicate that clear intention? It sounds like word choice is super important here.
Yeah, absolutely. So words like shall, must, or, on trust for
Right.
usually signal a much stronger intention.
Got it.
These terms impose a mandatory obligation on the trustee, so there's no room for misinterpretation.
Okay, so no more reading between the lines and
Right.
trying to find a trust where one doesn't exist.
Yeah.
I can see why that shift was important. You want to make sure
Mm,
you're respecting people's actual intentions, not forcing something
absolutely.
that they never meant, right?
Exactly. It's all about upholding the settler's autonomy
Right.
and making sure that the trust reflects their wishes.
This is really helpful for my revisions. Like you're explaining the why behind the rules,
Right.
which is really helpful for understanding how to apply them.
Oh, good. I'm glad to hear that. So, moving on to the second certainty.
Okay.
Certainty of subject matter.
Okay, so this is all about the what of the trust,
Uh-huh.
the actual
Oh, see,
property or
sorry.
assets being held, right?
Exactly. The subject matter of the trust has to be clearly defined. You can't have a trust over some of my money or a few of my shares. It needs to be specific and identifiable. Imagine you're trying to bake a cake
Okay.
and the recipe just says add some flour.
Disaster. You'd have no idea how much to use,
That
and the
would be-
cake would probably flop.
Yeah, exactly. Total flop.
Yeah.
The same goes for trusts.
So,
The assets need to be clearly identified so that the trustee knows what they're managing
got it.
and the beneficiaries know what they're entitled to.
So what are some common examples of things that can be put into a trust?
Oh, it can be almost anything. Land, money, shares, personal belongings, even intellectual property rights.
Okay.
But the key is clarity. If someone says, my favorite painting is going into the trust,
Yeah,
but they don't say which painting,
right.
that's a problem waiting to happen.
Yeah, what if they have like multiple favorite paintings?
Exactly.
It's like a legal riddle waiting to be solved.
It is, and that's where the courts come in.
Yeah.
They've had to deal with so many cases where the subject matter was unclear
Oh, I bet.
or poorly defined.
So cases like Palmer v. Simmons and Hunter v. Moss are good examples of how these issues play out
Absolutely.
in real life, right?
Yeah, they're great examples. They give you real insight into how judges interpret this requirement.
I'm definitely adding those to my study list.
Yeah.
It's so helpful to see how these principles actually translate into court decisions.
Yeah,
It
absolutely.
makes it much easier to understand
Yeah,
the nuances and complexities.
I agree. And that's why we're going to be looking at those cases in
That's right.
more detail in future episodes. But for now, the main thing is to understand the core concept.
Okay.
The assets in the trust must be clearly defined.
Got it.
Otherwise, it can fail because there's just not enough certainty there.
Okay, so we've covered certainty of intention, making sure the person meant to create the trust. We've covered certainty of subject matter.
Right?
So, like knowing exactly what assets are involved.
Yeah.
What about the who factor?
That brings us to our final certainty: Certainty of object. Oh, there's all about identifying the beneficiaries,
Okay.
the people or entities who are supposed to benefit from it.
Okay, got it. So if you're setting up a trust, let's say, for your family,
Mm-hmm.
you would need to clearly define who those family members are.
Exactly.
Otherwise, you could end up with like family feuds
Right.
and legal battles over who gets what.
Absolutely. Yeah, and traditionally, this meant you needed to be able to write down a complete list
Oh, wow.
of all the beneficiaries.
Okay.
And this was known as the complete list test.
That sounds pretty straightforward.
Yeah.
But I can imagine it could get complicated quickly, especially with larger families
Mm-hmm.
or trusts that are meant for, like a broader group of people.
You're absolutely right. And that's where things get a bit more interesting. The complete list test worked well for, small fixed trusts.
Yeah.
But it was super challenging, sometimes even impossible. For larger or more complex trusts, especially those with like a more fluid group of beneficiaries,
Right.
like employees of a company or residents of a particular town.
Yeah, trying to come up with a complete list
Right.
in those situations would be crazy.
It would be a logistical nightmare.
Yeah, it sounds like you need a more flexible approach.
Exactly. And that's where a landmark case
Okay.
comes into play. McPhail v. Dalton.
Okay, I'm intrigued. So before we dive into McPhail v. Dalton,
Yeah.
let's take a quick pause. We'll be back in a moment to unpack this game-changing case
Thanks, guys.
and find out how it transformed the certainty of object landscape.
Okay.
Okay, so we're back and we're ready to talk about this McPhail v. Dalton case.
Yeah.
You mentioned it kind of introduced a new test for this certainty of object.
Mm-hmm.
What was so groundbreaking about it?
Well, McPhail v. Dalton really changed things in trust law. It challenged that old complete list test,
Right.
especially for these discretionary trusts. Remember, those give trustees flexibility in deciding, which beneficiaries get benefits and how much.
Okay, so trying to apply that complete list to like a discretionary trust where there's a ton of people
Right.
or a group that changes over time would be
Exactly.
pretty much impossible.
Exactly. And that's exactly what was happening in McPhail v. Dalton.
Really?
The trust was set up for the staff of a company, their relatives, and dependents.
Oh, wow.
Trying to make a list of every single person in those categories would have been a huge task.
Yeah, I can imagine. So what did the court do?
Mhm.
How did they solve this?
So the House of Lords, this was a landmark decision.
Oh.
They abandoned that strict complete list test for discretionary trusts,
Got it.
and they adopted a new standard, the is or is not test.
Is or is not. Okay.
Yeah. So instead of needing a complete list, you just need to be able to say with certainty whether any person or is not part of that group of potential beneficiaries.
Okay, so it's less about knowing every single person by name
Right.
and more about having criteria to figure out
Yeah,
who qualifies.
exactly.
It sounds a lot more practical, especially for those bigger, more fluid trusts.
Exactly. It brought in some much needed flexibility to
Right.
trust law. But of course, any new legal test, brings up questions about how to apply it.
Right, because is or is not
Yeah.
sounds simple enough in theory,
Mm-hmm.
but I'm guessing in real life,
Yeah.
things can get messy.
Oh, absolutely.
How do you determine those boundaries?
That's a great point. And that's where a case called Rabadan's Deed Trusts, No. 2, comes in.
Okay.
This case looked more at how to actually use the is or is not test,
Okay.
especially for those broad terms we see in trusts, like relatives and
Right.
dependents.
Yeah, those are classic examples of terms
Well,
that can
yeah.
mean a lot of things.
Absolutely.
So how did the court handle this in Rabadan's deed trust? Do they make things clearer?
They did. They recognized that, getting absolute conceptual certainty with terms like relatives and dependents is difficult.
Yeah.
They said the important thing is whether the definition is clear enough
Okay.
for the trustee to actually do their job, basically to decide who is and isn't a beneficiary.
So there's a little wiggle room.
Yeah.
Like as long as the trustee can, for the most part, make those decisions.
Exactly. It's not about getting rid of all uncertainty. It's about having a framework that works
Okay.
and allows the trust to be managed properly.
This is really helpful for my revision. It's showing how things work
Good. I'm glad to hear it.
in practice,
Yeah,
not just, the theory.
absolutely. So to see how this new test works in real-world scenarios, let's look at Ree Barlow's will trusts.
Okay. What happened there?
In this case, the testatrix, she left a bunch of paintings
Okay.
with instructions that her friends could buy them
Oh, wow.
at a discounted price.
That's nice.
Yeah.
But defining friends legally
Right.
seems really tricky.
Incredibly difficult. Friendship is so subjective. How do you define that legally?
Right.
But the court didn't let that ambiguity just stop everything.
Oh.
They were practical about it, and they said a friend in this situation could be someone who had a long relationship with the testatrix,
Okay.
one that showed mutual trust and affection.
So they focused on, like, the
Yeah.
relationship itself rather than trying to come up with this strict definition.
Exactly. And this allowed the executor to actually carry out her wishes,
Right.
even though friends wasn't, perfectly just defined.
That's really interesting.
Yeah.
So even though we have this new, more flexible test from McPhail v. Dalton,
Mm-hmm.
courts still look at the specific situation
Yes.
and use common sense.
Absolutely. It reminds us that law isn't just about rules. It's about finding a balance between the principles and what's actually practical.
Okay, so we've talked about how a trust needs to be clear about who the beneficiaries are,
Right.
what happens when the definition is too broad.
Yeah.
Like, is there a limit to how many people it can include?
That's a great question. And it brings us to administrative workability.
Okay.
Basically, a trust can fail if there are just too many beneficiaries, to the point where the trustee can't manage it.
So even if you can say whether someone is or is not a beneficiary,
Yeah.
the trust can still be a problem if the group is just
If it's unmanageable.
too massive.
Right. Imagine a trust for, like, all the kind people in the world.
Oh, wow.
Lovely sentiment,
Right.
but legally, it just wouldn't work.
Right. How could you even find all the kind people?
Exactly.
And then how do you decide who gets what? It would be total chaos.
It would be chaos, and the courts have recognized this.
Okay.
In cases like RV District Auditor,
Yeah.
they've shut down trusts where the group of beneficiaries was just way too big.
Okay, so there is a limit to how big a trust can be.
Yeah.
Even with the is or is not test.
Exactly. You still need a reasonable level of certainty and practicality when you're defining those beneficiaries.
This is really helpful for understanding the boundaries here.
Good.
It's not just about one test, it's about making sure the trust can actually function.
Exactly. Balancing those legal principles with what's practical.
Okay, so what are the key takeaways here for our listener who's studying for this exam?
Okay, so first, remember, McPhail v. Dalton changed everything for discretionary trusts.
Right.
It's all about the is or is not test now, which is more flexible
Right.
than that complete list test. But you still need some clarity.
Right, it's not a free-for-all.
Exactly. The definition of the beneficiaries needs to be clear enough
Yeah.
for the trustee to do their job and for the courts to be able to say whether the trust is valid.
So cases like Rebaden's deed trusts,
Yes.
Rebarlow's will trusts,
Yeah,
those give us some good guidance.
absolutely. Those are really helpful for seeing how to use the is or is not test.
Yeah.
They show how important context is, how you need workable definitions,
Right.
and how the court tries to uphold what the settler wanted.
It sounds like there's always this tension between making sure things are legally sound,
Yeah,
but also honoring, like, the spirit of the trust.
that's a great observation.
Okay.
And as you keep learning about trusts, you'll see this tension pop up a lot.
Okay, this has been really helpful for understanding these concepts and seeing how they work in real life. It's making my revision process a lot more engaging.
I'm glad to hear it.
You did mention that McPhail v. Dalton wasn't, like, the end of the story.
No, it wasn't.
Have there been any other developments since then in this area?
Oh, absolutely. McPhail v. Dalton gave us a more flexible approach,
Yeah.
but later cases have explored its boundaries and clarified some things about the is or is not test.
Okay.
Like, for example, Retux settlement trusts.
Okay.
That case looked at the role of third parties in resolving uncertainty.
Oh, that's interesting. Can you tell us a bit more about Retux settlement trusts?
Yeah.
Like, how did it add to our understanding of certainty of object?
So in this case, there was a trust with a condition. The beneficiary had to be married to a woman of Jewish faith.
Okay, that's a pretty specific condition.
It is.
That brings up some questions, like,
Yeah.
did the court have to define Jewish faith?
That's where it gets really interesting. The settler, he actually thought about this. He knew it could be ambiguous.
Right.
So he named a chief rabbi as the authority on matters of Jewish faith.
So he put a system in place
Yeah.
to handle any uncertainty.
Exactly.
And-
And the court upheld it.
Okay.
They recognized that it provided a practical solution to a complex issue.
Right. It shows how someone setting up a trust can plan ahead, and prevent ambiguity
Absolutely.
to make sure things run smoothly.
Yeah, retux settlement trust shows that the court wants to make sure things are certain,
Right.
but they're okay with using mechanisms set up by the settler
Okay.
to resolve any uncertainty.
So it adds another layer
Yeah.
to this is or is not test.
Absolutely. It's not just a simple formula. Right.
It needs careful thought and application.
It seems like there's always more to learn about trusts.
Oh, absolutely.
Yeah.
It's always changing. Every case adds something new.
This has been really helpful.
Glad.
I feel like I'm starting to get this whole certainty of object thing
Yeah.
and why it matters so much for trust law.
Yeah.
Before we finish up, is there anything else our listeners should know about certainty of object? Any other cases or developments? So we've been talking about certainty of object and how this is or is not test really made things more flexible, especially for discretionary trusts. Are there any other big cases that can help us understand this concept better?
Definitely. There's another case that shows us how the courts deal with certainty of object,
Okay.
especially when you have these terms that can be kind of subjective.
Right.
It's called Regelbankian settlements.
Okay. Regelbankian settlements. What makes that one stand out?
So in this case, they had a trust set up.
And it was for the benefit of, well, get this, any person or persons in whose house or apartments, or in whose company, or under whose care or control, or by or with whom the said Nubar Sarkis Gulbenkian may from time to time be employed or residing.
Oh, wow, that is a mouthful.
Right.
It sounds super broad
Yeah,
and really open to interpretation.
it is.
How could a trustee ever figure out who actually benefits from that?
That's a great point. It's a really complex and kind of ambiguous clause.
Yeah.
But the court in Regelbankian settlements, they didn't just give up. They really dug into the wording, trying to figure out what the settler meant,
Okay.
and to see if they could come up with a way to apply that is or is not test.
So how do they make sense of something that sounds so vague and subjective?
Well, they focused on the fact that even though the clause was broad,
Mm-hmm.
it wasn't completely unlimited.
Okay.
They looked at the main parts, like residence, employment, company, care, and control.
Okay.
And they said that a potential beneficiary had to have a real solid connection with this Nubar Sarkis Gulbenkian
Right.
in at least one of those areas.
So it wasn't enough to just like have met him once or something. It had to be an actual meaningful connection.
It had to be a real connection.
Right.
The court said even in a broad clause like that,
Yeah.
there has to be some way to figure things out objectively.
Right.
The trustee can't just decide randomly.
Right.
They need evidence and criteria.
This case really shows how important interpretation is
Yeah.
when you're using the is or is not test. It's not just about following a formula. It's about understanding the situation,
Absolutely.
what the settler meant, and all the specific details of the case.
It shows that law is always evolving.
Right.
And even tests that seem straightforward need careful thought.
Okay, so to sum up our deep dive into certainty of object,
Yeah.
what are the main things our listeners should remember for their revision?
All right, so first, remember McPhail v. Dalton? That was huge.
Okay.
It shifted us to the is or is not test for these discretionary trusts.
Got it.
Yeah.
But even with that flexibility, you still need clarity.
Right. It can't be too vague.
Exactly. That definition of who the beneficiaries are has to be workable.
Mm.
The trustee needs to be able to manage the trust,
Right.
and the courts need to be able to see if it's valid.
And cases like Re-Badden's deed trusts, Re-Barlow's will trusts, Re-Tuck settlement trusts, and Re-Gulbenkian settlements.
Those are great examples.
Those really show us how the is or is not test works in real-life situations.
Absolutely. They show how courts use context, interpret things reasonably, and try to honor what the settler wanted.
This whole journey through certainty of object has been really helpful.
Good. I'm glad to hear that.
It's amazing how this one concept has changed over time, and I feel much more confident about tackling it in my exam.
Excellent. Remember, those three certainties are the foundation of trusts.
They are, yeah.
Understanding them is key for anyone working with or studying trust law.
And as you keep learning about this area of law, you'll see these concepts come up again and again. Absolutely, they're everywhere.
It's like we've unlocked a secret code to understanding trusts. Well, thanks so much for guiding us through this deep dive.
It's been my pleasure.
I know our listener has learned a lot from you.
I hope so.
And to our listener, we'll be back soon with more deep dives into other key areas of law. Until then, keep those legal minds working.